Hi, welcome to day 2 of 3 of our Business Resiliency series, the financial, legal, and human impacts of navigating through COVID-19. This series will feature local experts that will share their professional experience and guidance on all things COVID-19. Today, we have Christian Rodriguez of Trembly Law walking us through some of the legal implications of COVID-19. My name is Danae Zamora, and I'm a district manager for ADP Total Source. I'll be your moderator for this series. I'll begin by asking our experts some questions, and we'll end our program with a live Q&A. A reminder to please mute your phones, and the chat feature is open for questions to be submitted and answered during the Q&A. We kicked off our series on Monday with a CPA at KSDT, who shared some expert knowledge and key insights on the state of the federal programs available to businesses. Some key takeaways from Monday are that there are many resources and factors to consider, but 3 things really rang true. Cash flow is a top priority, planning and forecasting is a must-do for every business, and quality data and systems will be critical now as well as in the future. Our expert today comes from Trembly Law Firm. Trembly Law Firm's mission is to protect the economy one business at a time. Trembly Law Firm provides general counsel services to businesses and also practices in the areas of business law, employment law, franchise law, and litigation. I do need to share this brief disclaimer before we get started. Due to the unprecedented events, there are various and rapid changes in the law which may result in some of this information being outdated in the future. This information in this presentation is accurate as of April 8, 2020. Trembly Law Firm is keeping up to date with rapid changes for the benefit of its clients. And now to our expert. Today's expert is Christian Rodriguez. Christian has successfully defended business owners in jury trials for various types of claims ranging from breach of contract to shareholder disputes to employment discrimination. He's also helped several business owners negotiate and avoid potentially damaging business claims and employment cases, commercial lease disputes, and ADA Title III cases. For 4 consecutive years, he's been selected as a rising star by super lawyers. With that, Christian, I'd like to welcome you to our series.
Thank you very much for having me, Danae.
Great. Well, Christian, I definitely want to get started with what the first question I asked KSDT on Monday. Really, what's the most challenging part for businesses as a result of this pandemic?
Sure, that's a great question to start us off. So I like to say that the COVID-19 pandemic has pulled off our cloak of invincibility. These are unprecedented times in modern world, and a lot of people, don't believe that it was foreseeable. It doesn't. Regardless of that, the truth of the matter is the hardest hit is going to be small businesses, especially the mom and pops. So, I've heard a lot from clients in the past. Oh, I don't need to worry about this or worry about compliance with this particular law because I've been operating 20 years and I've never had an issue. Well, now I think that a lot of those types of businesses are going to realize that they have a lot more exposure now because of COVID-19 and these unprecedented issues that are coming up. And, you just look to the government and the way they're handling this, and they're scrambling, right? Because it is completely unprecedented. So you have them enact on March 18th, 2020, the Families First Coronavirus Response Act, and then about a week later, they enact the CARES Act, and in between that and since then, there's been numerous regulations by the Department of Labor's Wage and Hour Division, the SBA, and Treasury, and there's overwhelming deadly changes. I mean, while I was preparing the night before the presentation, just as I thought I was done reviewing everything, SBA came out with the new FAQ and regulation about the Paycheck protection loans. And so all the information that we had been interpreting up to that point, some of it had changed drastically. So, I think that's the greatest change is this environment of constant change and uncertainty, and that's why it's important to have professionals like ADP, like Trembly Law, and others that can help guide businesses through this.
Well, businesses definitely need to start somewhere. Even though it's a dynamic situation, from your expert opinion, where do they get started so that they can prepare and they can overcome this whole situation? Like, what should a business get started in preparation with?
Sure, and the key here is that businesses can overcome this. This will pass. any experts, medical experts that you've heard speak about this, they talk about the curve, and the curve will die down over time, and we will get back to business, but business will change, right? And so there are some key things that businesses need to do to make sure they overcome this COVID pandemic, right? The first thing is they need to gather or hire, and this is an important thing, listen to a team of compliance professionals. And when I say compliance professionals, I mean business and employment lawyers, accountants, HR and payroll companies, benefits administrators. And the reason that this is so important is because businesses need to take reasonable and good faith efforts to comply with the laws to the best of their ability. And unfortunately, it's not something that's easy for businesses to navigate themselves. And that's why you need these professionals to help you, because there's a saying that an ounce of prevention is worth a pound of the cure. And that rings true now more than ever. Okay? What it costs to take proactive measures is significantly less than trying to undo things later on. Okay? The third thing that businesses need to be doing is securing cash flow. That's very important. That's what KDST was talking about on Monday. And there's numerous options out there, from the Paycheck Protection Program to the Economic Injury Disaster Loan Programs to bridge loans, tax credits, and other kinds of funding that businesses need to get their hands on to be able to pay for basic services to keep their business running. And the fourth thing they need to do is to prepare for the comeback. So you've got to think with the end in mind. What are you going to do once this pandemic is over? How are you going to get your business back? How are you going to avoid issues or address issues as they come up? Because we are fully expecting that there's going to be a wave of a lot of litigation and disputes once this is all done. And so the important thing for businesses to be doing is to make sure that they are keeping the relevant documentation. And there's a lot of it and things that we can go through as we go through this presentation.
Yeah, it's actually not the first time I'm hearing, something to this effect, Christian. It's such a great perspective. A business owner actually told me last week that every company can survive a strong economy, but those who right now are putting in the right strategies, have the right team behind them, and ultimately the grip to adapt to what the future will be are going to be the ones that weather the storm and come out better on top. So I guess with that, you mentioned, complying with the law. I know you've been guiding your clients a lot on that. What can you tell us about the Families First Coronavirus Response Act, the FFCRA?
Sure, and we'll call it the FFCRA just to keep it short because that's a mouthful of a title. So the FFCRA was enacted on March 18th, 2020, okay? And the intent of the law was to protect the employees of businesses that had less than 500 employees, and they call them small businesses, right? And many of you may think that a business that has 499 employees is a large business, but for purposes of this act, it's considered a small business. And the act creates two types of emergency leave, okay? It creates emergency expanded FMLA leave. FMLA refers to the Family and Medical Leave Act, and it also creates emergency paid sick leave. Now, parts of the FFCRA were amended by the Coronavirus Aid, Relief and Economic Security Act, which we will call the CARES Act. And the other important thing to know is that the FFCRA is a temporary law. It went into effect on April 1st, and it expires on December 31st of this year. And it's being enforced by the Wage and Hour Division. And they have issued a rule that they will delay enforcement until April 17th, provided that employers engage in reasonable and good faith efforts to comply. But they have been very insistent that even though they're delaying it until April 17th, they will retroactively enforce it going back to April 1st. So compliance is a big concern here. You have to make sure you're in compliance.
Like employers going forward, and do you really think there's going to take a lot of time enforcing this, especially with everything going on?
It's going to be interesting to see whether or not they go ahead and they just start randomly enforcing this, or if they're going to wait for claims, right? Usually what initiates the Wage and Hour Division to to initiate an investigation is they receive some sort of claim or complaint from an employee. And the reason that you're going to probably see a lot of this is because as businesses furlough employees, as they lay off people, as they reduce hours, in my experience, having defended wage claims, having defended discrimination claims, and various other employment actions, is that the catalyst for those types of claims being brought is some sort of adverse employment action, because this is an emotional thing for people. People are scared as it is, and when you take away their ability in their mind to earn a living and to get through this time, they react emotionally, right? And the first thing they do is say, I need to go talk to a lawyer. And when a lawyer is telling them, hey, I can possibly get you money out of this, and these people are desperate, it's very likely that they're going to start making claims at that point. So the ultimate, I hear a lot of businesses tell me, oh, well, I have a family relationship with my employees. It's like a big family here. And, I tell them that's great, but I hear that a lot with people when they get married, and it doesn't turn out that way when they get divorced, right? So the point here
yeah, that's true.
The point is to be prepared. So how it affects employers, the first is, from a cost perspective, right? So a lot of employers are closing, they're facing zero revenue or drastically reduced revenue, and they're concerned, how are we going to pay for this? And that's somewhat some of what KDST went into on Monday. Okay? There's also compliance concerns, especially with teleworking and remote work. It's changed the complete dynamic of the way things are normally done, right? And so you still have to comply with all of the other employment laws that exist on the books. It's not just the FFCRA. You still have to comply with the Fair Labor Standard Act, overtime and minimum wage matters. You still have to comply with anti-discrimination laws, with whistleblower laws. And so there's a lot of potential pitfalls if you're not properly prepared, if you don't have your policies and procedures, and if you're not trained as to how to avoid these issues. Because a lot of this stuff can be prevented with the proper preparation, right? So you got to make sure that you are avoiding wage and hour enforcement actions, that you're taking steps to avoid claims and lawsuits, and that you have all the proper documentation that you need. And the other way that this is affecting employers is that it adds additional concerns when considering whether they can furlough, lay off, reduce wages, or reduce hours of their employees, and whether they should allow teleworking. There's even the consideration of what they're calling intermittent leave under the FFCRA. So it's not something that employers should be navigating on their own, as you can see.
No, I would totally agree. It kind of sounds to me like the perfect storm. I have to say, even me working from home, there's so much daytime TV of saying, hey, this happened to your work. Are you being paid for this? Did you get terminated? Something bad happened to you, those adverse actions that you just referenced. And then they say, but do you want to sue your employer? And definitely people who are at home today are seeing those commercials. So when I say it's the perfect storm, it's all of these additional layers of things businesses have to comply with, on top of opportunity and the potential to get some sort of money from it at no cost to you. I definitely think it's the time to double down on compliance and making sure you have the right team. Christian, who do these new laws and regulations apply to? What companies are covered by the FFCRA?
Okay, so the FFCRA applies to any companies or employers with less than 500 employees. If they have more than 500 employees, they're not covered. And the Department of Labor has indicated that you're supposed to use a live calculation, which is the number of employees on the day the employee's leave would start. There's been some criticism that this requires some sort of psychic ability on behalf of the employers to calculate this, but ultimately the point is you just have to be keeping active records of how many employees you have. And the more employees, the more important this is. That's not to say it's not important if you're a small company. Okay? Now, the following employees may be excluded from the leave by an employer: healthcare providers and emergency responders. because they are critical employees that need to be working. And you also, when you're calculating this 500 employee cutoff, you have to consider if you're a joint employer. And the Department of Labor issued frequently asked questions. And question number 2 goes into a little bit of an explanation of what kind of factors the department will look at to determine whether you're a joint employer. And this is most common when you have a business that owns multiple franchise locations, right? So let's say that you are a business owner and you decided to buy 2 different UPS locations, one in Miami and one in, Broward, let's say, right? And you have employees that work at both locations because they need additional hours. Well, now you got to do the analysis to see if that changes whether you're a joint employer and whether you hit that 500 employee number.
Really interesting. So it sounds like a lot of companies, not a lot of exceptions of who this wouldn't apply to. So there's a lot of entitlements it sounds like employees are going to be getting and things that employers need to cover. I guess those 2 types of leaves that you shared. Let's start with that emergency FMLA leave. What are those employees entitled to under the emergency FMLA?
Let's first, if it's okay, let me explain who qualifies for it, right? So an employee is entitled to FFCRA's expanded FMLA when they have worked at least 30 calendar days with the company and they are unable to work or telework due to care for minor children if the school or childcare has been rendered unavailable because of COVID, right? So that was what FFCRA stated. The CARES Act also expanded this so that the following employees would also be entitled. And those are employees who were laid off by the employer after April 1st, 2020, had worked for the employer for at least 30 of the last 60 calendar days prior to the layoff, and were rehired, or were rehired by the employer. So this is a drastic change from the traditional FMLA leave. Under the traditional FMLA leave, they had to have worked at least 12 months prior to leave, at least 1,250 hours during this period, and worked at a location where the employer had 50 or more employees within 75 miles. None of that applies to this.
Looks like there's a lot more people who fall into the bucket of qualifying for this. What do they get?
They are entitled to 12 weeks of emergency FMLA leave. Now, a very quick caveat to this. You are entitled to a total, when you combine emergency expanded FMLA leave and traditional FMLA leave, a total of 12 weeks of leave in a 12-month period. That's important because let's say earlier in the year, you took 6 months because of a medical procedure, right? Well, then under the emergency FMLA, under the FFCRA, you would only be entitled to 12 weeks of this additional leave. To 6 weeks of this additional leave. And the way that the leave works is that the first 10 days are unpaid. And the employee can use PTO during these 10 days, but the employer cannot force them to use it. Okay? Now, after the 10 days are over, the Department of Labor's FAQs indicate that for FMLA leave, that if there's existing PTO or leave, that the employer can require the employee to use their existing paid leave concurrently with the benefits they're going to receive for the last 10 weeks. So the next part of this is after those first 10 days pass, thereafter the employee is entitled to 2/3 of the regular pay rate up to $200 a day and $10,000 in the aggregate. And the other important thing to note is that once this leave is completed, once they finish their 12-week leave, that the employer has to provide restoration of the same or equivalent position. And the exception to that is if you have less than 25 employees and the position no longer exists because COVID-19 required you to change your business practices or to get rid of that position. So again,
interesting. I can imagine as some businesses are navigating today, like what my employees are entitled to, what I need to give them, what acts they belong to, not only do they need to have a plan today, how they're going to get it right, but even decisions in the future, they have to have a system that basically tests it against how all of these, employee entitlements factor in. What about the emergency paid sick leave? Can we jump into that one?
Yeah, of course. So the emergency paid sick leave, employees qualify if they meet one of the 6 categories. Number 1 is being subject to quarantine or isolation order. And the Department of Labor's FAQs have indicated that shelter-at-home orders may be sufficient to trigger this. Category number 2 is being advised by a healthcare provider to self-quarantine. Category number 3 is experiencing symptoms of coronavirus and seeking medical diagnosis. Category number 4 is caring for an individual that is subject to quarantine or isolation order or has been advised by a healthcare provider to self-quarantine. Real quick point on that. If you decide on your own to self-quarantine, that doesn't trigger any of these categories. You have to have an order from a healthcare provider to self-quarantine. Category number 5, caring for a child whose school or place of care is closed or no longer available due to coronavirus. And for purposes of this one, the Department of Labor has indicated, even if your child's school is still doing classes over the internet, right, that's still considered school being closed because the physical location is closed. And number 6 is suffering any other substantially similar conditions specified by Health and Human Services in consultation with the Secretaries of Labor and Treasury. So this is just a catch-all in case if the virus mutates and they want to be able to include those people in these categories.
What will those employees be entitled to if they do fall into one of these 6 categories?
That's a great question. So depending on the category, the answer is it depends on the category, right? So if you're qualified for reasons or categories 1 through 3, you're entitled to up to 80 hours at regular rate of pay, so 2 weeks. It's capped at $511 per day or $5,110 in total. On the other hand, if you're qualified for categories or reasons 4 through 6, you are entitled to up to 80 hours at 2/3 of your regular rate of pay, and you're capped at $200 per day or $2,000 in total. Now, you're also even though under normal paid sick leave regulation, you are not entitled to job protection, the CARES Act does require that an employer provide job protection for an employee that is getting emergency paid sick leave. And one thing important to note is that category number 5, the child care one, is the same qualifying event for the Emergency Family and Medical Leave Act leave. So if you are having to take leave because your child's school is closed or because you don't have child care due to COVID-19, you could qualify for both the emergency FMLA leave and the emergency paid sick leave.
Those are some great points on both of those different types of leave. It sounds like such an equation to see where people fall into, what they're entitled to, and probably administering these to all the different individuals in your company, because the rules that apply to one person aren't necessarily going to carry through to every individual that brings the need to take leave to HR. It's going to be different, it sounds like, for everybody. One thing I want to jump over to, sorry for cutting you off, is, a lot of businesses are considered maybe like a non-essential business, and their employees, are they entitled to leave when they're not even open or bringing in any sort of revenue?
Sure. So before I go to that question, I just want to make a quick illustration to the last point you made, which I thought was very important. The way I look at it is each business is a puzzle, and each of the employees is a different puzzle piece. And not each puzzle piece is going to be the same, and it's not going to fit the same. So you have to treat each one individually, okay? So it's not a simple answer for, oh, you have 50 employees, here's what you could do for all of them, right? You have to actually look at each employee individually. Now, as to your the next question you had asked, if a business is closed because they're a non-essential business and there's a local state, or because they just don't have the business. While that work site is closed, you don't have to provide leave, right? Because and they even go so far, when I say they, the Department of Labor, it goes so far to say that even if you have an employee that is receiving leave while during the time when you close, you only have to pay them up to the time that you close. So only for the time you were owed. And their position is that when it does close and the leave ends, that employees can apply for unemployment insurance. And under the CARES Act, they actually expanded who's eligible for unemployment to furloughed employees and to self-employed persons.
Interesting point there. I would say in the world of pre-COVID, we rarely heard the word furloughed. Usually only in maybe a school term or a government term we ever heard the word furlough. Can you share a little bit about like the difference between a furlough and a layoff, and how a business kind of weighs out the two for themselves?
Yeah, of course. So a furlough is a mandatory unpaid time off from work. And the key characteristic of a furlough is that the employer-employee relationship continues during the furlough. And therefore, once the furlough ends, people who are furloughed can expect to return to their job. Now, the duration of a furlough depends entirely on the employer. And the other thing that's important to note is that in some circumstances, if the employer provides benefits to an employee, like group health insurance or an IRA program or retirement, in certain circumstances, the employee can still collect certain benefits during the furlough period. But if there's any contributions that are required by the employee, then the employee may have to continue making those contributions. So this is one of the reasons that I said at the outset that it's important to have a benefits administrator on your team of compliance professionals, because you don't want to be getting into issues regarding any benefits law or ERISA law, which is a very specific and niche area of the law.
That's probably one of the more expensive ones too.
Oh, absolutely. You don't want to even go near there, because if you not only can you get in trouble from the legal side, but your benefits program may have certain penalties written into it that you, the employer, have to now incur, right? So it's just additional costs that you're not even anticipating, and you don't want any surprise costs during this time. So contrast a furlough with a layoff. A layoff is when an employer dismisses employees. And the main difference here and the main characteristic of a layoff is that a layoff terminates the employer-employee relationship, and there's no expectation to return to work. So the question I've gotten from a couple people is, so once I terminate the relationship, that means I don't have to worry about a benefits administrator. That's not correct. You still have to talk to them. For example, if you were providing group health insurance, you may have there may be COBRA obligations, and there may also be continuing obligations through a certain pay period. So you need to make sure that you are doing things above board at all times, so it doesn't come back to bite you. And you don't want the Department of Labor going in to investigate a wage and hour claim and then also realize that there's ERISA issues. It's just not worth it.
Yeah, it's actually coming from the world of Total Source here at ADP. Those are some of the areas where we've been busier than ever, helping existing clients navigate these things, because we help them not only when it comes to compliance from the traditional pre-COVID world, everything from state regulations, federal regulations, but now that they need to issue, mass COBRA notifications or communicate with their employees. Those are the types of things we've been able to help with. And I have to say the feedback from clients is it's been brilliant, and it's been such a peace of mind for them, because, outside of Total Source, they would have been Googling as their, future HR department, and who knows what they would have been subject to. Something I'm curious of now with the FFCRA, if an employer wanted to take any of these actions, whether it be furlough, layoff, maybe reduce hours, can they even do any of those things, or what's that relationship like?
There's usually two questions that I get asked relating to this. The first part of it is can the employer do this? And then a lot of times I get the second question, which just goes to show that, a lot of small businesses are not doing this to hurt employees, right? They're doing it because they're terrified and they don't know how they're going to be able to pay them. So the second question they always ask me related to this is, well, I'm not going to say always, but most of the time ask me is, will it hurt our employees' ability to get unemployment if I do this, right? And they're concerned about their employees. So the first part of that, the first question is, can the employer do this? The answer is generally yes, so long as there is a legitimate business reason that is not discriminatory and not retaliatory. And you can look at the answers to questions 25 and 43 from the Department of Labor's FAQs. Now, just so before I continue, real quick note on these FAQs, okay? They're good information, and I encourage business owners to read it, but what I don't encourage business owners to do is to try and navigate these laws just based on those FAQs, or to try to interpret them completely on their own. Because a lot of the terms in there and a lot of the analysis and rules that they refer to also reference to other laws, other regulations, and case law, which the average person is not going to know how to interpret, right? And you may be taking a word or a phrase in its colloquial sense, not realizing that it has a very different meaning in terms of these regulations. So even though it seems like, oh, this is easy, I can do it myself and save money, don't do it. Remember, an ounce of the prevention is worth a pound of the cure. So going back to what I was saying, while the answer is that generally yes, they can do furloughs, layoffs, reduction of hours or wages, right? It's a case-by-case basis. You have to document everything, and you also have to be aware that there could be potential consequences for other laws. For example, if you reduce someone's wages and they were considered an exempt employee under the FLSA, you need to make sure, if you want to keep that exemption, that you meet the minimum pay threshold and that you're also not changing substantially the duties of what they're doing. And like that, there's many other things, potential pitfalls you have to be aware of. So when I say that it's a case-by-case basis, I kind of look at it as a two-part analysis, right? First is the employee entitled to any leave under the FFCRA? Okay? And an attorney can help you, a knowledgeable attorney can help you decipher this. If you see that there is an employee that is entitled to leave, right, and that person has requested leave or is receiving leave, you just have to make sure that when you implement this furlough, layoff, or reduction of hours, that you are documenting a legitimate business reason for doing these things. Because if not, you can fully expect, as we were talking about, the emotional reaction, right? One of the things that, one of the prohibitions in the FFCRA is that you cannot retaliate against someone for requesting this leave or taking this leave. And the timing is important. If they request this leave and then you subsequently lay them off or furlough them, then they will try to argue that, or they can try to argue that it was retaliation, right?
Right, and I would say when you bring up that point of you can't retaliate, and if someone even tries to see or communicate that they are entitled to leave, I would say a lot of employers that I've talked to that are essential and are still operational, they're already so frustrated by trying to navigate these things that taking action, it's just a big headache to figure out what they're entitled to and not having a reaction if they are frustrated. So I think having a third set of eyes for perspective would definitely be of value, especially not only are the employees emotional, but I would say most business owners right now are emotional.
Oh, absolutely. I mean, especially when you're talking about a small business, many of these business owners started off just themselves and maybe a family member helping them out. And now they've grown to 6 or 7 employees or 10 employees. And so they've put in a lot of work. They've probably put in a lot of money and time. And now they're worried about losing their investment on it. So yeah, absolutely. So going back to the second part of that analysis, so can the employer do this analysis? So the first part was, is the employee entitled to any leave under the FFCRA? And the second part of it is, even if an employee is not entitled to any benefits under the FFCRA, are they doing this in a way that complies with all other employment laws, right? And there's a lot of them. So you just need to go through the analysis and have a knowledgeable employment attorney guide you with how to do it, right? The other thing you have to be wary of, remember I said that there were sometimes collateral consequences. Well, if you're applying for a paycheck protection loan and you want the forgiveness, right? The Paycheck Protection Program reduces the amount of your forgiveness if you reduce your workforce and if you reduce your workforce's wages by more than 25%. So you also want to keep that in mind if you are looking to maximize the amount of forgiveness you get under the Paycheck Protection Program.
Yeah, sounds like a full minefield. Any action that you take has a reaction on the other side that has to be considered. Question, if employers get in that position where they do need to take some sort of adverse action, I think most want to put their employees in a position where they're able to get unemployment insurance. How would that be possible? What would be the best way to do that?
If it's a furlough or a layoff, the CARES Act has extended the unemployment insurance to furloughed employees, and laid off employees are traditionally entitled to unemployment insurance. For reduction of wages or hours, there's no law at this time that entitles them to it. Like I mentioned, if the reduction of wages or hours is more than 25%, it will affect your PPP loan forgiveness. It may result in losses of FLSA exemptions. And remember, FLSA is the Fair Labor Standard Act, which governs overtime and minimum wage requirements. You also need to make sure that if you're reducing wages or hours, that you're not going below the federal or state minimum wage. And you need to make sure that you're in compliance with your policies and procedures. So, ideally, each business that operates and has employees has employment manuals, employment policies, and procedures. Before you take any actions, you need to look through them and have your employment attorney look through them and make sure that whatever actions you take are in compliance with your own policies and procedures. Otherwise, that could come back and really hurt you. So, not only for reduction of wages or hours, not only can it hurt you, the employer, if you don't do it correctly, but it also can hurt your employee to the extent that the employee can't get unemployment insurance. Now, what I have seen is that when they reduce wages or hours, sometimes they allow the employee to supplement with their existing paid PTO or paid sick leave under the employer's plan. But no employer is required to do that. It's just I've seen that happen in some instances.
Interesting options. Anybody who maybe can apply for like an exemption from the FFCRA, but any options there?
The only one that I've seen so far is a business with less than 50 employees. They can request an exemption from the Department of Labor from providing either type of leave. And if you remember, there was those 6 categories for the emergency paid sick leave. And I noted that category number 5 was the same qualifying event for the expanded FMLA leave. And that was if your child's school is closed or you no longer have child care available because of COVID-19, right? So it doesn't apply to all those others, the remaining 5 of the 6 categories. And in order to get this exemption, an authorized officer of the business has to determine that one of the following applies. Number 1 is that providing leave would cause the business's expenses and financial obligations to exceed its revenues and cause the business to cease operating at a minimal capacity. Or number 2, the employee's absence would entail a substantial risk to the business's financial health or operational capabilities because of specialized skills, knowledge of the business, or responsibilities the employee possesses. Or number 3, there are insufficient workers who are able, willing, and qualified to perform the labor or services provided by the employee requesting child care leave, and these labor or services are needed for the business to operate at a minimal capacity. Now, they have not, the department has not yet issued regulations as to how to apply for this. They've only said, have your authorized officer of the business make one of these findings in writing and do not mail it to us. Hold on to it, because when the application process starts, then we'll tell you to go ahead and submit.
A great recommendation there. When it comes to the leave, since some of that is paid and businesses are looking for some financial support, when it comes to the Paycheck Protection Program, can we talk a little bit about this and the key aspects of this loan?
Key aspects of the Paycheck Protection Program is that it was created by the CARES Act to promote employers not to terminate jobs and to help pay for FFCRA leave. The borrower will have up to 8 weeks to use that loan, and that's called the covered period. And it can be used for payroll costs, rent, mortgage interest, utilities, and interest on debts acquired before February 15, 2020. Now, the CARES Act did away with traditional loan requirements. You don't have to prove the ability to pay back this loan. You don't have to give a personal guarantee. You don't have to give collateral. Okay? And I think the most attractive feature of this loan for people is that it's forgivable up to the amount of the principal and accrued interest. So the initial term of this loan will be for 2 years, and it'll have an initial interest rate of 1%. After you apply for forgiveness, whatever amount is not forgiven will have an interest rate of up to 4% and a maturity date that lasts no more than 10 years from the date of the application. Now, if you've ever applied for a traditional line of credit, you know that the average interest rates for lines of credits are between 5 to 7%. So a loan at 4% and up to 10 years of maturity is really not a bad deal. The important thing to note is that there are many businesses that are also applying for economic injury disaster loans, the EIDLs, and initially it was understood by everyone, and it was reported that you could apply for both the EIDL and PPP, the Paycheck Protection Loan. Well, on April 2nd, late at night, the SBA issued the internal rule, which indicates that after April 3rd, borrowers cannot apply for both the EIDL and the PPP. So that's made a significant change. And if you go to the next slide, we can talk a little bit about the criteria. So to be eligible for the Paycheck Protection Program, you have to be a business with less than 500 employees that was in operation on or before February 15th, 2020. You can also be considered, be eligible if you're considered a small business concern under the SBA's rules. And under those rules, businesses, even with more than 500 employees, may be entitled. In addition to that, nonprofits with less than 500 employees, as well as self-employed, self-proprietors, and independent contractors will be eligible. And you need to sign, there's a bunch of certifications, including certifications that you were in operation on February 15th, that the funds will be used only for the approved uses and to retain workers, acknowledging that a max of 25% can be used for non-payroll if you want the maximum loan forgiveness, and that you can only receive one paycheck protection loan under the program. You also cannot be in the process for applying for another loan for the exact same purpose, and you cannot be taking the benefit of the employee retention credit under the CARES Act, or the FFCRA. So there was a tax credit which your accountant can explain better to you, but it allows employers to retain certain aspects of the employer's payroll contributions, and to use that money instead to pay for payroll expenses and other qualified expenses. But if you do take advantage of that, then you can't do the PPP loan. So how do you calculate the amount? So the amount is the lesser of 10 million or 2.5 times the average monthly payroll cost. And payroll cost is defined in the Act, so you should look up that definition, because there are certain things that are included and are not. Generally, what is included is wages, salary, commissions, bonuses, non-cash benefits like group health insurance or employer contributions to retirement plans, and payment for PTO. What is not included in payroll costs? Federal taxes, FICA, the employer's contribution, that's not included in the payroll cost calculation, nor is any cash compensation in excess of $100,000, right? So the example I give is, let's say that you have an employee that earns $120,000 a year plus benefits. Well, when you're doing the calculation, you can only account or include in the calculation up to $100,000 of the cash salary, but you can also add to that the non-cash benefits, right? Any employer contributions to retirement plans or group health insurances, okay? And with the new rule, the interim rule that the FBA issued, they clarified independent contractors will now have to file for their own paycheck protection loan, and employers cannot include any wages paid to someone as a 1099 independent contractor in this calculation. So as you can see, there's a lot of nuances to this.
For sure, and I can imagine as you're calculating not only the amount that you do, we've talked about the leaves that people are entitled to, and the whole relationship between any action a company takes and how everything is really related. I can imagine everyone pursuing this paycheck protection program is going in with the intention of wanting to make sure they do the right thing to get it forgiven. Can we walk through some of how the loan forgiveness works? Because I think that's a pretty unique program that will be new to a lot of companies.
Yeah, it essentially turns this loan into a grant, up to 100% of the loan, even though a lot of people we'll probably see a substantial forgiveness portion, but maybe not 100%. And we're waiting to see how this is going to work out. But like I mentioned before, it's forgivable up to the amount of the principal as well as any accrued interest. And whatever amount is forgiven is not taxable income, and any expenses can be deducted. Now, the expenses should be lower because the fees should be paid out or amortized into the loan. But we're waiting to see how that's going to play out when they start processing these loans. And the amount of the loan forgiveness is the total cost incurred and payments made during the forgiveness period, right? Remember, we said the covered period was 8 weeks after the loan is made. And the costs that you can include in this calculation are payroll costs, mortgage interest, rent, and utilities. Now, note that I said mortgage interest, not mortgage principal, okay? And the law also allows you to include certain debts that the company owes that were incurred before February 15, 2020. Now, the important thing, like I said before, is that the FBA has issued in their interim rule a requirement that to get the maximum amount of forgiveness, not more than 25% of the loan amount can be used for non-payroll cost expenses. And I anticipate that, there's probably going to be some litigation on this issue later, because the law itself doesn't impose such a restriction. And under basic separation of powers doctrine, the argument can be made that the FBA administrator doesn't have the right to change the law as written. So I fully expect that as soon as people start getting denied for their for portions of loan forgiveness because of this arbitrary 25% number, that you're going to start seeing lawsuits being filed, right? The other thing that's important to know is you have to document or provide documentation of authorized uses that will support the loan forgiveness amount. And the lender will have 60 days to provide you with a decision on your application. And if you took out the $10,000 emergency grant under the economic injury disaster loan, then your loan forgiveness will be reduced by this amount.
Yeah, that point about documentation of authorized uses, that's now the second time we've heard this. On Monday, they really dove into wanting to make sure employers knew this. There's so much potential to get this forgiven if you're doing all the right things. It doesn't mean go buy a boat. What it means is use this to keep the business sustained and employees as whole as possible. And it means being responsible as far as tracking where these funds are going, that they're in the right percentages. So again, it definitely seems like a time where experts should be leaned on. Trial and error isn't going to work because there's so much to jeopardize if you do the wrong things and are not able to get the maximum amount of forgiveness. Can we walk through a little bit more about those requirements for the loan forgiveness?
One of the requirements to maximize your loan forgiveness amount is that you have to maintain your levels of employment and compensation, and meaning wages, the same as the time that you applied for the loan. So if you reduce staff or decrease compensation between February 15th, 2020 and April 26th, 2020, then the forgiveness amount will be reduced. And unless they are rehired or your compensation is raised back to regular levels, by June 30th, 2020. If you do it by that date, you will be able to, you won't have a loan reduction. The other caveat of that is that if you are going to reduce wages, you can't reduce it more than 25% year over year. The only exception to that is employees making more than $100,000, right? So if you're making more than $100,000, you've already seen twice that that's a cutoff number for that.
What about a lot of people on the call anticipate they're going to be able to weather the storm? What are some things from your expertise, and you've worked, in the legal field for so long, you've seen situations like this before. What are things employers need to be thinking about as they prepare for the new normal?
One thing is, we've seen tough times. I think this is somewhat different from the things that I've seen before, but it's not so drastically different that we don't have an idea what to do, right? The same type of principles apply. People always try and compare this to the economic downturn back in 2008 and 2009 with the mortgage bubble burst, but it's strikingly different in a lot of ways. But the important thing to remember, and I saw this quote somewhere the other day, it made me kind of laugh, but there has to be a little bit of levity in this, but it says, "This too shall pass. It may pass like a kidney stone, but it will pass." And if you've ever had a kidney stone, you know that it hurts. And you know that it's difficult while you're passing it, but after you pass it, after you get back to normal, you almost forget what it was, right? I've heard the same thing about childbirth, but I couldn't even begin to to pretend that I know that. I said this at the beginning, and I'll say it again. You need to lean on a team of compliance professionals, all right? And there's a cost-benefit analysis here. People are worried, oh, well, I don't want to spend my money on that, right? If there's anything I can tell you to spend your money on, it's payroll, your necessary expenses, and part of those necessary expenses includes compliance professionals, okay? Because they will help you get through this and help you mitigate a lot of damage and a lot of costs later on. The cost of litigation can be astronomical. The legal system here has a lot of benefits, but there's a lot of criticism about access to justice, right, or access to the court, because the cost of litigation can be, astronomical for some businesses. If you're taking a case all the way to a jury trial, for example, a business can fully expect to spend six figures on that just in attorney's fees, right? And when you consider that one litigation by itself could cost you six figures, and you could get compliance professionals involved for low five figures, I mean, it's just a basic business analysis, right? A basic business decision. And when I say low five figures, I'm talking about everybody, trying to work together, trying to figure out what's the most economical way to get people involved. So you get your compliance professionals. You've got to make reasonable and good faith efforts to comply with the laws. You've got to secure your cash flow, and you've got to prepare for the comeback. You've got to be proactive here, right? Ignorance of the law is not a defense. So just telling the Department of Labor or telling a judge, oh, I didn't know that what I did was wrong or that it was illegal. Listen, the judge and the Department of Labor are not going to care, right? They're going to say, listen, there were webinars everywhere. There were articles all over the place. You just decided to stick your head in the sand. That's not a defense, okay? And this has been a long-standing tenet in the law way before this has ever happened, way before I was even born, way before many of my grandparents were born. All right, don't assume that you can just say I don't have to worry about it because I can just say I didn't know. You need to be organized. You need to be prepared, and you need to have a plan.
You talk about, a team being in place and wanting to have things organized, and it makes total sense with everything that's going on. One of the things I really want to ask you, is there any type of lawsuit that you're expecting, as an aftermath of COVID-19?
How much time do you have? I mean, look, it depends on what we're limiting it to here, because I think what you're going to see is you're going to see a stream of contractual cases. You're going to see cases about breach of contracts. You're going to see commercial lease disputes. You're going to see from the employment realm a ton of cases, and they're going to all vary, right? So I fully expect that you're going to see, wage and hour claims coming from a lot of people that are being furloughed or laid off, because like you mentioned, this is the perfect storm. There's an attorney whose website is Sue Your Boss. Imagine on the one hand, you're being told, look, we have to let you go. You're not going to get paid. You go then to apply for unemployment. The unemployment system is down. So you're trying to figure out how you're going to pay for food on your table. Here comes this attorney saying, I'll get you money. Of course, people are going to take them up on that. So you're going to see wage and hour claims. It's going to be interesting to see what role telework plays into this, because teleworking or remote work, you still have to comply with the FLSA's overtime requirements. And part of those requirements are that you have to keep accurate and reliable time records. You need to also make sure that in addition to the employees writing down their time and keeping these records, that they're also logging any breaks, because they're not supposed to be working more time just because they're at home. Otherwise, what happens is that you end up potentially not paying overtime, or not realizing that you owe overtime because you're not keeping good records. And then later on, that just gives an attorney like the Sue Your Boss attorney leverage to try and get money from your business. I
guess I'm curious, what are some things a company can do to get ahead of some of these things as they've sent people home to do teleworking or work from home, pretty rapidly? What are things they could do even today that gets them prepared for, protecting themselves from some of these claims?
Yeah, sure. So I'm going to talk generally, and a lot of these things will apply to telework also. But the main thing is, when I say that the Department of Labor and the Wage and Hour Division is very clear that employers need to take reasonable and good faith efforts to comply with the law, I'm not just talking about the FFCRA. I'm also talking about FLSA. And in addition to that, Economic Employment and Opportunity Commission, the EEOC, is similarly investigating discrimination claims and retaliation claims, right? So the way you do this is to implement or update your policies and procedures to effectuate all of these laws, including the FFCRA. And you've got to train your officers, your executives, managers, and supervisors on this law and on how to communicate with the employees, how to implement these policies and procedures, what record keeping needs to be done, and how to deal with these inspections and investigations. Because even before this all occurred, I had clients in the past that would call us freaking out saying, oh, the Department of Labor just showed up. They've been with my employees for the last hour. What do I do? And I feel like telling them, you rewind the clock an hour and you should have called me immediately. But these same employees, remember I was saying at the beginning that people have this feeling that there was this concept that they had this cloak of invincibility. A lot of these clients are the same clients that we told many times, listen, let us do a training. Let us help you understand what your people need to do. And a lot of them didn't want to spend the money. And this goes back to my point. It's a cost-benefit analysis. You don't want to be caught unprepared. You want to have your people trained. You want your people to know what they're supposed to do in those circumstances and to mitigate the potential risks to your business. it's a no-brainer.
Yeah. I mean, at ADP, we have like over 40 different solutions that everything from like record keeping, training, compliance, really trying to do those proactive measures as well. People are always so surprised to hear that ADP, you think of it as this big powerhouse when it comes to payroll, but that's only actually less than 30% of our revenue as a company comes from payroll related services. The rest is compliance, human capital support, trainings, record keeping. That's where for 65 years we've been the leading expert in all of these areas. You know, Christian, I definitely want to thank you for your time today. And we're really lucky to have someone of your caliber share all of this insight with our market. I'm sure the business owners, I speak for them as well, a big thank you as we all try to navigate next steps and making sure we're taking care of each other, our business, and planning for the future. I think everything you shared will be a big help. And on your behalf, you know, I invite everyone on the call to contact Trembly Law for, you know, further personalized guidance. You can visit their website at tremblylaw.com, and they can also be reached even now, all working teleremotely at 305-431-5678. Christian, again, thank you so much for your time today.
Created a text line for people who need to contact us and feel better texting. You can text PPP Help, right? PPP, like the Paycheck Protection Program. So PPP Help to 31996, and then someone from our team can get a hold of you, can get in touch with you promptly. So thank you so much for having me, Danae. I really appreciate Danae. I'm sorry. I really appreciate it, and I really appreciate this partnership with ADP. And thank you to everyone who's been part of this and participated in this presentation. Thank you for your time and thank you for your attention.